Everyone. My name is Mirna Dzeletovic. I work as a judicial assistant at the Court of Appeals in Novi Sad, and a theme of my PhD thesis is a legal position of a child in its wrongful relocation in the country and abroad. In my thesis, among other things, it was discussed child's residence and parents' right to change it under the Serbian law. Under the Serbian family law, there are two types of exercise of parental rights, joint and independent. Parents exercise parental rights jointly when they live together, and when they do not live together, but they make an agreement that they will continue to exercise parental rights jointly, and court finds that agreement to be in the best interest of the child. On the other hand, one parent exercises parental rights independently on the basis of court decision or on the basis of law, when, for example, other parent is unknown, is not alive, has been deprived of parental rights or legal capacity, or in case when a parent lives with the child alone and court has not yet made the decision about parental rights. Under the Serbian family law, to change a child's residence, consent of both parents is necessary, regardless of whether they exercise parental rights jointly or one of them independently. So under the Serbian family law, one parent cannot change child's residence without the consent of the other parent in any case. At the same time, Serbian Act on Permanent and Temporary Residence stipulates that the registration of a child's residence is submitted by his or her parent. This act stipulates that when parents exercise parental rights jointly and they have the same residential address, one of them can submit registration of child's residence without the consent of the other parent. Also, this act stipulates that when one of the parents exercise parental rights independently, that parent can submit registration of a child's residence without the consent of the other parent. At this place, we can conclude that provisions of Serbian Act on Permanent and Temporary Residence are not harmonized with the provisions of the Serbian family law, because Serbian family law stipulates that for every child, to change a child's residence, you need to have consent of both parents. And under the Serbian Act on Permanent and Temporary Residence, for example, parent who exercise parental rights independently can change child's residence without the consent of the other parent. And at the same time, Serbian Act on Travel Documents stipulates that the request for the issuance of a travel document for minor is submitted by one of the parents with the written consent of the other parent. This is the case when parents exercise parental rights jointly, and we can see that one parent cannot request for the issuance of a travel document without the consent of the other parent. Also, under the Serbian Act on Travel Documents, a custodial parent can request the issuance of a travel document without the consent of the other parent. This is also problematic paragraph because it is not harmonized with the Serbian family law. Also, under the Act on Border Control, when parents exercise parental rights jointly, and one of them wishes to cross the state border with the child, the consent of the other parent is not necessary. Also, when the parent who exercises parental rights independently wishes to cross the state border with the child, also does not need the consent of the other parent to do so. We can conclude that provisions of these three acts are not harmonized with the Serbian Family Act, because under the Serbian Family Act, parents who exercise parental rights independently need to have the consent of the other parent to change child's residence. And under the other three acts, this parent can register child's residence without the consent of the other parent, can submit the request for the issuance of a child's travel document without the consent of the other parent, and can cross the state border with the child without the consent of the other parent. Regarding parents who exercise parental rights jointly, under the Serbian Family Act, they jointly and mutually decide on every change of child's residence. And under the other three acts, one of these parents can register the child's residence without the consent of the other parent when they have the same residential address. And one of these parents can transfer the child across the state border without the consent of the other parent when they jointly exercise parental rights. For the purpose of writing my PhD thesis, I studied relocation cases before the Court of Appeals in Novi Sad. When we say relocation cases in Serbia, we mean procedure for partial deprivation of parental rights to decide on issues of significant influence to a child's life. The study included relocation cases in period from 1st of January 2011 until 1st of September 2019. And although we're talking about a period of almost 9 years, number of relocation cases is not significant. In this 9-year time period, we have only 31 relocation cases. Out of this 31 relocation cases, 14 procedures were international relocation cases, and 17 were domestic relocation cases. Claim was upheld in 17 procedures, and mothers submitted claims in 20 out of 31 cases. Due to this small number of relocation cases before the Court of Appeals in Novi Sad, it was concluded that parent who wants to move with a child manages to change a child's residence based on the solutions contained in other three acts, which give the parent such powers, but are not consistent with the Serbian family law. That is why the study proposes that the solutions contained in the other three acts, which are more administrative in the nature, harmonized with the solutions of the Serbian Family Act, which comprehensively regulates family relations, all in order to improve the position of a child whose rights and best interests will then be more protected. That would be all from me. I hope that you enjoyed.